Thank you. We're going to talk now about federalism, and the full title is really Federalism and the 17th Amendment. Federalism is a huge topic. I teach a course on federalism in the law school, and it's endlessly fascinating and becoming increasingly important in our political discourse. In 15 minutes or so, I can't do more than give us an overview, and I wanted to have a focus, and it's going to be the 17th Amendment. And I want to challenge you to rethink some foundational attitudes that we might have about how the Constitution works. So here's the hypothetical we're going to start with. The government passes a statute making it a crime to say anything bad and untrue about the government, about the president, about the members of Congress, about the Supreme Court justices, and whomever. Now, you read this in your paper, you shake your fist, no doubt. This sounds un-American. Doesn't mean you get sued. This is a crime. You'll go to jail if you say something bad about the president and it turns out not to be true. And even if it does turn out to be true, that's just your defense in the criminal prosecution. You're still going to get arrested if you say something bad about the president, et cetera. So our immediate response would be, this is unconstitutional. Why? Because it violates the First Amendment, right? It violates the free speech clause of the First Amendment. And I'm going to go where to protect my rights? I'm going to court. I'm going to get the Supreme Court to say that this is a violation of my First Amendment rights. That is a post-Civil War attitude. It would not have occurred to anybody in the early days of the Republic to do that. And in fact, Congress did pass that statute. In the Adams administration, it was called the Sedition Act. It was passed about the time that the Federalist Party started to feel that it wasn't looking so good in the upcoming presidential election. And they decided one way to deal with the Jeffersonian opposition was to criminalize saying or publishing bad things about the incumbent president and his party. And they arrested a number of people, and there were some fairly high-profile cases. People sent to jail or fined for violating the Sedition Act. It became, not surprisingly, a major campaign issue. But what is surprising to us moderns is that the argument wasn't, this is a violation of the First Amendment, and it certainly wasn't, and we're going to the Supreme Court to get them to safeguard our rights. What the opponents of the Sedition Act argued, Jefferson, Madison, and many others, was this is a violation of the list of delegated powers that Congress possesses in Article 1, Section 8. This is an ultra vires, as they say in corporate law, exercise of power. In other words, the federal government can only do those things that we said they could do in the Constitution. There's a list of them in Article 1, Section 8. It's established post offices, raise an army, coin money, pass a naturalization law. Nowhere in there does it say that Congress has the power to pass a statute criminalizing bad-mouthing Congress. It's not in their power. So they're acting outside the scope of their delegated powers. And who are we going to get to say that to them? And this is the other surprise for modern audience. Not the federal courts, the state legislatures. Madison had said this in the Federalist Papers. When people were worried about, well, what if the federal government gets out of control? And he said, well, the answer is simple. The state legislatures will be the principal protectors of our rights. And they will get together and they will stop the federal government from engaging in the exercise of ultra vires power, or excessive power. And that's the response that Madison and Jefferson came up with to the Sedition Act. They got the Virginia legislature and the Kentucky legislature each to pass resolutions saying this is unconstitutional because Congress doesn't have the power in Article 1, Section 8 to pass a Sedition Act. And then they called all the other legislatures and said, come on, you all join in too. And the other legislatures, and this was turned out to be the big problem with the plan, said, I don't know. And nobody else would pass resolutions. Nobody else would pass resolutions. The Sedition Act ended up not being declared unconstitutional. It ended up dying. It had a sunset provision. When Jefferson came in, he declined to enforce it and then just sort of let it go. There was a brief flurry a few decades later where federal sedition as a crime reappeared as a federal common law claim, and that disappeared immediately too. And we haven't had a Sedition Act since. But again, it's important to realize that it's not because of the First Amendment. It's because it wasn't delegated. And the principal defense was supposed to come from the state legislatures. The states, it's hard for us to conceive of how important, I mean, we talk about federalism and all this stuff, but how important to the anticipated operation of the federal structure, states as states speaking through their legislatures were originally intended to be. There, you know, you can spend lifetimes, and folks do, studying the secession debate and all of that, and there's a lot of meat to it, and there's plenty of material to read because there was an enormous amount of discussion about just what it is that states are supposed to do in the federal system. One of the ways that this perceived to be important role, this liberty-preserving role, was incorporated into the Constitution was in Article 1's provisions relating to the selection of senators. Members of the House, we've talked about a lot. You count how many people in your every 10-year census, and then you add 3/5 of all the slaves to the total number of free people, and then that gives you a figure, and then you divide it by, and everybody gets that some proportion for representation. But the senators, 2 per state, were to be selected by the state legislatures. And that's the way it operated. That's the way the government operated right up until the 17th Amendment was adopted in 1913. Now, things happened in between, right? The most important, of course, being the Civil War, which was the great crisis point for federalism. It was the death knell for slavery, of course, and that's how we appropriately remember it. But it was also a crisis point, not the death knell, but a crisis point for federalism. When the war finished, the victorious states viewed this power that the antebellum Southern states had possessed in the constitutional infrastructure as having been responsible for the war in large part. If they hadn't been overrepresented, if you know, the state legislature sending their senators there to do their bidding, you know, it's these states acting on their own that have created a problem. They haven't turned out to be, from the northern viewpoint, preservers or protectors of liberty. They've turned out to be oppressors. Oppressors. That was the view of the southern state governments. So 2 of the 3 Reconstruction Amendments, the second, or rather the second and third of them, the 14th and 15th Amendments, both begin by yelling at the states. No state shall. No state shall. There had been limitations on state action in the original Constitution, but not very many. They were sort of taxes on interstate transactions and coining money and stuff. Now it's much more substantive than that. No state shall deny any person equal protection of the laws. No state shall deprive any person of life, liberty, or property without due process of law. This is the federal Constitution telling states that they've got to start behaving differently. No state shall deny to any person the right to vote on account of race. That's the federal government interfering in the state franchise, which was unusual for the time. And it signaled the direction in which things were going to go. Now, the post-war period is very interesting on the federalism issue, and I think understudied because we're interested in different topics. But I'll give you, for instance, and this is a historiographical comment as much as anything. There is a case of which you've probably heard. It's the E.C. Knight sugar case, or you may have heard of it. It's the Sugar Trust case. Congress in 1890, well, let me back up a little bit. Part of what happened during the Civil War was the economy became much more centralized than it had ever been. And that's largely thanks to the need to manage a war. Lots of fortunes made by government contractors. Lots of improvements in the transportation infrastructure, because we got to get cannons down to Mississippi, we got to get uniforms to Northern Virginia to the troops, so the train system is improved. Lots of experience gained in centralized multi-state economic activity at the governmental level and by private parties. The economy sort of nationalizes during the war in a way it hadn't, and huge fortunes are made after the war by persons who had profited from this expansion of the economy. We're still officially a state's sovereignty constitutional order, so the states are left trying to regulate this economic activity after the war is done, and it becomes quickly apparent that it's more than they can handle. So Congress in 1890 passes the Sherman Antitrust Act that says, we'll take it from here. So economic monopolies, you've now committed a federal crime, and the federal government is going to police it. The constitutionality of the Sherman Act's application to one trust, the Sugar Trust, was a group of sugar manufacturers who had taken control of 90% of the sugar, or plus, of the sugar industry in the United States. And the federal government went after them and said, this is a violation of the Sherman Antitrust Act. It's a monopoly. And the sugar manufacturer said, you can't touch us because we're only doing business in one state. We're manufacturing all of our stuff in an individual state. And yeah, we sell it to folks who take it all over the place, but that's their problem. You can't stop us from doing what we're doing. That's for the states to do. The trust won in that case, and when we teach it, we tend to teach the E.C. Knight case as, you know, restriction on the scope of the Commerce Clause power, as evidence of the power of the robber barons, the captains of industry in the late 19th century, and how the court was supporting the economic power structure. And that sort of, that's a bit anachronistic, though, I think, because there's a lot more evidence that what's really going on in E.C. Knight is the court, in sort of an old-fashioned look to the past, thinking, well, you know, let's give the states a crack at this. You know, the old state structure still has appeal, despite the Civil War. So let's let the states see if they can solve this problem. And of course, it turned out that they couldn't. And this is the problem with the national economy. It's a problem in any country with national problems where a lot of the enforcement power resides in the individual constituent parts and not in the whole. Because you just move. You just run around, and you can avoid prosecution going from one state to another, or avoid regulation. And it's only when the national government steps in as a practical matter that the problem can be solved. And that's the way that the federal government was thinking about it at the time, and I think the court wasn't so much. This movement against the trusts begins in earnest about this time. The people who are really mad at all of this consolidation of economic power are farmers and consumers. Farmers, because transportation monopolies are created. So if I own all the trains, I can charge you whatever I want to charge you to take your grain to market. And I can raise that price as high as I want to, and you're stuck. And consumers, because they're paying higher prices for things like sugar, because there's a monopoly control over the cost of sugar. Or other things I hadn't never really heard of before I became a constitutional law professor, like jute bags. There's a big jute bag trust. Some of you may also know, I actually know what jute bags are now, but I didn't when I was a kid. So there are lots of trusts that organize. And the Populist Party forms to combat the trusts. And one of the biggest culprits they identify in this problem is the state legislature. They think that the state legislatures are being corrupted. Remember, E.C. Knight has left it to the state legislatures to solve the problem, and they're not. The populists decide that the state legislatures are being bought, and that's part of the reason that they're not introducing aggressive anti-monopoly legislation. So at their party platform in drafting session in 1892, the Populist Party decides to go after the Article 1 provision allowing the state legislators to name the senators representing that state. And what they want now is they want the people of the state to be able to pick those state senators. And this movement takes off. It appears in the 1892 Omaha platform. It garners increasing support as the populist movement increases in power and grows in rural communities. These charges of governmental corruption at the state level stick in some instances. And by 1912, there are 27 states ready to call for a constitutional convention to get rid of or replace this method of selecting senators with direct election of senators by the people of the state. 27 states. At the time, they needed 31. And that was a little too close for comfort for Congress. Congress feared that if the populace got a constitutional convention around this issue, at a convention, you can do anything you want. And there would have been 1,000 additional amendments introduced, and the whole Constitution would have been hijacked by the Populist Party. So Congress hurriedly drafts the 17th Amendment, pursuing the alternative route for amendment. Senate passes it, the House passes it in May 1912. The thing goes out to the states, the 17th Amendment providing for materially for the direct election by the people of senators. And within a year, 3/4 of the states have ratified it. The whole focus of the ratification campaign is corruption in state legislatures, democracy, direct accountability of senators. Hardly anybody talks about the impact on federalism and the federal structure. The old system, in the old system, the senators, as we've discussed, were essentially ambassadors from the state. They received instruction from the state legislatures. And you see this a lot in the record. The legislature of Virginia hereby requests the members, its members, and the members of the Virginia delegation, the House of Representatives, and instructs its senators to vote as follows. And that's how the power was divided and how it worked. That wasn't talked about when the 17th Amendment came up, except by a handful of people, and the thing swept through in a crowd of popular support. And in 1913, we shifted to a constitutional order in which people of the states directly elect their members of the Senate. And the senators no longer represent the legislatures of the state as they did. They represent the whole citizenry. It may interest you to note, and this is a bit of an aside, that not every state ratified the 17th Amendment. They all didn't have to. You just needed 3/4, and that number was reached within a year. The states that didn't, interestingly, there were 8 that never have, and 5 of those 8 are former states of the Confederacy. Florida, Virginia, Georgia, Mississippi, and South Carolina never ratified the 17th Amendment. 3 other states didn't. Kentucky didn't. They were also a slave state. And Rhode Island and Utah, which are sort of quirky. So they didn't either. There were, interestingly, and this is something a lot of people don't realize, three other states have ratified, but they didn't in the initial run-up. Alabama didn't ratify until 2002. So they were a holdout initially. And then came around. Delaware ratified in 2010. The 17th Amendment, it's a century old. And Maryland ratified last April. In April Fool's Day 2012, the state of Maryland ratified the 17th Amendment, which is now a century old. Apparently the Maryland legislature was out of session when the vote came around to ratify, and by the time they came back into session, there were already 3/4 of the states that had approved it, so they figured there wasn't any point. And they sat on it, and they decided this last session that, yeah, it was about time to join the rest of the team. Not that it wasn't effective in those states. They have been directly electing their senators. But that's the way it worked. Now, what happens after that, I'm going to save for a different lecture. The federal structure changes dramatically in the 20th century with the New Deal, the new federalism in the Reagan years. But as I say, it's too full a subject to exhaust in 15 minutes or so. So I'll leave you in 1913 with a constitutional reordering And then at a future date, we can talk about what that's meant since for our constitutional order and specifically our federal structure. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.